it's amazing that you're all here, and it's amazing we're doing this. This started 2 years ago in South Dakota. My wife and I were at a national conference, and I attended a training given by a South Dakota University person. And she was a lawyer, and she talked about leases, and I got really inspired. And I kept trying to contact her, but you know, we just go around in circles and circles and circles. Finally, we connected. She sent me her slides. We talked. I spent a lot of time on the internet. I spent a lot of time talking to Steve. I spent a lot of time talking to Alex. Short version, it snowed like crazy when we were going to come here a week ago. Now I hear it's blowing like crazy. So it's amazing. We got as much as we did done, but we have. So with that introduction, I've read Steve's slides. They're pretty thorough as far as what his background is. He's real. So Steve.
All right, thanks. And today's your lucky day because I brought Kelly Graves with me. Kelly's actually the real expert here. She's a real estate attorney in her office. And so didn't know she was going to present with me. Otherwise, I would have put her name on the slides as well. All right, so with anything when it comes to legal side, you know, a lot of times it depends on, you know, what side of the table, what side of the hedgerow are you on? If you're a seller of a farm, you want very different provisions in your agreement than the buyer wants. And the same is true with leases. If you're a tenant, there's certain things that you're going to want to see in there. There's things that you probably don't want to see. And if you're a landlord, you know, the same is true. There's absolutely things you want and some things that you might not want. So the law firm, we're with the Scolaro law firm. We're based in Syracuse. We actually have a couple offices across the state, one in Rochester, one in Leroy, office down in Florida. We really work and travel across the state. I was out in Chautauqua, Cattaraugus counties back in February. I was up in Malone a couple weeks ago. Didn't get out in the Hudson Valley. Kelly does a fair bit down in the Hudson Valley, working with the green markets, New York City. Jeff Fetter does work on Long Island. So we really do cover the entire state. Attorneys that are admitted in New York, Pennsylvania, I'm admitted in New Jersey, Vermont, Massachusetts. And we serve on, many of us serve on different boards, ag-related or ag-markets. And so we try to be involved in agriculture. And then I actually was a farmer. I grew up on a 40-cow dairy in Cooperstown, farmed with my dad for a number of years after I graduated from Cornell. Tried to work in the partnership not too far from where I grew up. When that didn't come together, I was out at Hemdale Farms in Geneva, and I ran the dairy there for 9 years, and then went to law school. Still actually own cattle to this day. Kelly, she's not a farmer, but she works with a lot of farm clients, obviously. Let's see.
Kelly wondered how many of you are folks who own rural land that you're renting to farmers? Just so it's easier for people to know.
The majority of you are landowners and are renting. We're the landlords.
So what we've kind of put together is, you know, calling them the 5 W's. These are things that we feel should be in any lease. And I mean, leases can be as complicated or as simple as you want them to be. So it can be a handwritten document that you put together yourselves, or it can be go to an attorney and get it written up. Our recommendation, of course, is to go to the attorney and get it written up. But, you know, we see a lot of handwritten lease agreements. Usually when we see them, though, it's because there's a problem. And someone's like, well, what does this mean? Or how do I get out of this? So, you know, our first rule is really, it should be written. If it's not written, you have what's called an oral lease. Those are okay, but they're very difficult to enforce because the problem is Keith and I can be having a conversation, and then 2 days later, I remember the conversation very differently than Keith remembers it. And that's the benefit of getting it into writing, because now everyone knows exactly what the terms are. And so you don't need an attorney, but I think, you know, it's advisable to at least have somebody look at it. particularly if you're getting into longer term leases. Maybe if it's a year, you say, oh, I'll hold the guy and be cheap about it, but it's usually best to get somebody to look at it. All right, so then, who are the parties? And it's amazing how you think, well, that's pretty easy, who's the parties? Well, we'll get documents, agreements, and they don't have the right parties because you don't really know who the landlord is or who the tenant is, and do we have correct names? And it's amazing. I mean, probably Kelly sees it more than I do with entity names being wrong. It's like they don't know that's an LLC, or they have a corporation and it's really an LLC, or they have a partnership and it's not even a partnership. And so, you need to know who the parties are, particularly if you want to have a valid agreement that you can enforce. If you're the tenant and you want to make sure the landlord has the ability, the authority to lease the land back to you.
No, I would just say, especially if you were in a default situation too, if the landlord is trying to collect rents and the tenant could say that they've been farming it, but the person that actually owns the animals or the crop, planted the crop, is a different person. So when you ask for your rental payment, you're talking to the guy that you've been talking to, but then you realize he wasn't the person that planted the crop, or he isn't the person that owned cattle.
Right.
So that can be problematic in enforcing the agreement. So if you know everybody's name and proper spellings of everything, when you go to enforce the agreement, you're much more further ahead.
And it's always good to have the address too, so that if we have to mail something or have the contact information of the parties, so at least you can reach back out to them in the future. And don't rely on a lot of people say, well, name on the tax bill, that must be who owns the property. Well, I know you'll find this hard to believe, but counties do make mistakes, and sometimes the name on the tax bill isn't all that accurate. Particularly, I see all the time with entities and trusts, the county will abbreviate it because I think they only have, 15 letters or something they're trying to squeeze in. So the tax bills, yeah, they're a great reference, but that doesn't necessarily mean that that's actually who the property owner is. So then the question becomes, what are you actually leasing? And, are you leasing land and buildings? Are you leasing all the land, the woods and the hedgerows and all that, or is it only the tillable land? Is it only the land on the east side of the road or the west side of the road, or what exactly is it? What about roadways? Are there farm access roads? Do you have the right to use those roads? Do you have exclusive use, or are you sharing that access with the landowner or somebody else? Maybe you're worried about water sources and, for irrigation or something. And do you have the right to the water source? And does anyone else have the right to the water source? Particularly if you're going to be using it for irrigation and crops, you want to make sure that you're going to be able to use that water. So we have to identify the property, and there's a couple of different ways to do this. And I don't know, Kelly, you want to walk through?
Usually, once you decide what you're going to be leasing to the person, again, the details, have more details and less details is always important. So the same tax bill, we can go off of the tax, if it's acreage, we can look at the tax bill and try to decide from there what the address is, how many acres based on the tax bill. Tillable acres is a little bit different because then you have to know what fields which could be part of a tax map identification, but you may only want a particular field within that tax map instead of the entire parcel. So it's really helpful for us to have that conversation with the landowner and the tenant to properly identify where the particular crop or animal is going to be during the lease period, so that there isn't going to be any mistakes in payment and enforceability of what the person's using, or the tenant is not using something you don't want them to use, such as farmhouse or surrounding yard at the farmhouse. And then I guess the same thing goes for being able to identify the roadways, that if you're also farming the property, whether you want to give them a shared use and how you want them to be operating, how, if you want them to have a certain, that they don't go too fast on the roadway or damage the roadway, you'd have to have a particular identifying factor to give them rules of engagement of how to treat your property when they're there too. And the only way to do that is to identify what they are allowed to use.
Because, you know, lots of times we'll see the lease and, you know, the example of Walker Farm. Now, my parents are still on the same farm. They've been there for 50 years. I think everyone in Cooperstown probably knows where the Walker Farm is and what it encompasses. So, you know, the common name can be okay, but like in this case, my parents are actually leasing land out. And so, you know, the west side of the road, they're leasing to somebody, and the east side, my dad's retained himself. And so we tried it in the lease, we spelled that out, that, you know, the west side of the road only. Kelly, I know she did a lease a couple months ago where they gave you field maps, right?
Yes.
You know, so it was just field maps, and we attached them to the lease, so then everyone knew it was this field and that field. Because again, they weren't leasing all of the property of the landowner, and they weren't leasing all of one tax parcel. It was just particular fields that they were getting the right to.
And we made the field maps exhibits to the lease, even though we're trying not to make it complicated, but in that particular case, it was a necessary evil to have exhibits to the lease so that everyone knew where the fields were that were being utilized by this particular farmer. So.
And, you know, again, roadways and things like that, you know, particularly if you're renting a farm or a dairy facility and maybe there's a personal residence there, you know, can you park your equipment, you know, in the driveway? And, you know, is that going to be okay? Or is that a shared driveway with the house? And it's like, no, you can't leave your tractor there overnight because that's going to be in our way. So those are all things that, you know, you need to look at the property and take into consideration. You know, when? So, you know, what's the term of the lease? When does the lease start? When does it end? Does it automatically renew? I mean, you can have a lease that automatically renews every year, every 5 years. You know, do the parties have to do something to automatically renew it, or is it just, you know, basically the lease says by default it's going to automatically renew? Although one of our litigators just sent a little blurb around that I wasn't even aware of, and there's a general obligations law that says that, was it a lease? The tenant, you can't have an automatic renewal unless the tenant consents to it. And it's not just residential leases, it's commercial leases. So we always put in language that says, yeah, this lease automatically renews unless the parties do something. But technically you should, if you're a landowner, you should get a statement from the tenant when the lease is up, just saying, yes, the tenant consents to this automatic renewal. Otherwise, under the law, the tenant can back out of the lease, even though it automatically renews. So again, it's just a crazy little thing. It's buried in general obligations law, which is a kind of obscure catch-all New York law, but something to keep in mind. So when you talk about term, you know, what's an appropriate term? You know, I think it depends on what you're leasing and what your plans are. So, you know, if you're doing corn, beans, and wheat, crops, you know, basically crops that you plant every year, you can do a short-term lease. You know, might be a 1 year, 2 year, 3 year. But if you start looking at doing, you know, investing in seeding and alfalfa and grass, you know, I think from a farmer, the tenant perspective, you know, the farmer wants a longer-term lease because they're going to have a lot of money tied up in establishing that alfalfa seeding. And so a 1 year lease isn't going to work for them. So you're probably going to have to do a 3 or 5 year lease. I gave this presentation to grape growers a couple weeks ago, and I mean, that takes them really about 5 to 7 years before they can establish their vines. So obviously, you know, a short-term lease for them isn't going to work very well.
I have a question.
Yes.
Is there any law that says that the assessor has to abide by, saying that you have to have a 5 year lease?
Right. So, and that's for ag assessment, that's in New York law where you have to have, if you're not, and it goes if you're trying to claim it and you're not operating the farm yourself, then you can claim it via a lease agreement, but there has to be a five-year written lease that. And what you're supposed to do is there's an affidavit of lease that you're supposed to submit with the application to get the ag assessment. So that's another reason why oftentimes we see 5-year leases for that reason alone. I know Keith, you've run into that, right? Or you've got a lot of questions on that. So, and then other things that could affect lease term is, without tiling. So if you want or expect your tenant to invest in tiling, which is going to improve your land as a landowner, that tenant's probably looking for a long-term lease. Because again, especially if you expect the tenant to pay for the tile. Now, if you do some kind of shared expenses, things like that, then maybe you get somebody to do a shorter lease. But if I'm representing a farmer who's going to do a lot of tiling, I want maybe a 10-year lease so that at least I can recoup, hopefully recoup most of my investment in tiling. And then, ditch cleaning, what happens if the fertility is down and you need a lot of lime or a lot of fertilizer more than kind of you would normally expect to kind of build up the soil health again. If you're a farmer, the tenant, and you're going to make those kind of investments, you're probably looking for that longer term lease to again recover your investment. So how much? What's fair rent? And are you going to get into any of this, Alex?
Not too much of that.
Okay.
So.
All right. We see a lot of triple net leases, and actually back, probably 5 years ago, triple net lease was kind of the way everybody went. Because the triple net lease was basically the tenant paid the taxes, the tenant paid the insurance, and the tenant paid any repairs to buildings. And 5-10 years ago, the landlord was pretty happy to find somebody who would use the land and pay their taxes, and so they basically have the farm at no cost. Now, you guys know that's changed dramatically here in the last 5 to 10 years, where now in the right place, cash rents are pretty considerable. I mean, I'm hearing prices from, and it's across the board. It might be $30 an acre up to $150, $200. I think I have some clients paying as much as $250 an acre if they're in the right part of the state with a lot of demand. So, triple net lease is great for the tenant. For the landlord, it covers their costs. So, they own the land. It doesn't cost them anything. In a lot of our family situations, that's what we do, triple net lease. Could be a fair market lease where, like I said, the tenant pays $200 an acre, and that's all the tenant pays. The landlord pays everything else. So the landlord gets the $200 an acre, the landlord pays his taxes, landlord maintains insurance, and keeps up the buildings, whatever. So there's no right or wrong answer. It just depends on what the parties are trying to accomplish. And then, do you do a fixed or variable rent for the term? So, do you start off, is it fixed for the lease, is it a 5-year lease and it's always going to be $200 an acre? Or, is it $200 an acre for the first 3 years, and then for the next 2 years, there's going to be some kind of increase? There's no right or wrong answer. It's just, what does everybody want? If you're going to do, the problem with the increases is how do you determine what the increase is? It can be predetermined, so you can say, okay, for the first 3 years, it's $200 an acre, and for years 4 and 5, it's going to go up to $225. You agree to that in the beginning, or you might say, it's going to be whatever the taxes went up, so that way, the landlord's like, I'm not going backwards. It could be adjusted for inflation or every other.
We just use the consumer price indexes. A lot of what our landlords and tenants were negotiating based on the consumer price index. But taxes is also a good way, but that could be 2 to 3% a year that they increase for that.
And that's what, if you're representing a landlord, that's always what bothers them is, okay, I'm going to rent to you for $50 an acre. That's fine today. I'm actually covering my taxes and have a little bit of money left over. But now in 5 years, taxes have gone up, and now I'm actually not getting enough rent to cover my taxes anymore, or my profit margin has has really shrunk. So you have to be sensitive to the landlord's concerns. And then that was just a couple of points left over from the vineyard presentation. You know, those guys have such a, and it could relate to tiling and other improvements. You know, if you're making a large capital improvement in the land early on, and you have a long-term lease, then maybe you do lower rent in the early years when you're establishing the vines or when you're doing the tiling. And then in the later years, the rent kind of jumps up. So it might not be so much applicable to corn and soybean ground if you're just kind of renting it, but. Okay. So other things. So those are kind of the, you know, those are the basics that every lease should have. You know, those 5 things should be spelled out in the document one way or the other, just to kind of protect all the parties. Then we've kind of got some other things that, you know, maybe you want, maybe you don't want. It's going to depend on, you know, what side of the hedgerow you're on. So, you know, are there superior rights? And this is where Kelly gets into this all the time with her, because she does a lot of real estate transfers and title work and whatnot. And so, you know, when you're renting the land from somebody, you could have someone who has superior rights to you if they have a mortgage against the land that's before yours, a lien, you know, basically anyone who comes first in time is ahead of you if it got recorded in the public record. You can explain it better than I.
Well, and again, it's first in time. So if you are leasing your property to someone and you also have a mortgage, the mortgage takes priority to the tenant's rights. But the tenant also will have, if you don't record a memorandum, nobody's on notice that you have a tenant in the property either. So if you were to default on the mortgage, then the tenant will find out probably by default in the sense that you're no longer there at the property if there's a foreclosure. I don't really know, you know.
Some of those take a long time though. And you may not know that as a tenant.
Right, or you may find that the bank is approaching the tenant and saying, don't give your rent to the farmer or to the owner, you're gonna give your rent to us because the owner has defaulted. So when you're making rental payments, and you're in default, you're collecting rental payments and you're in default on your property, either taxes or mortgage, then you're gonna find someone approaching the tenant to say, send your money our way instead of to the property owner.
Or from a tenant's perspective, you could lose the farm. So you say, well, I've got this long time, I have a 10-year lease. Well, if the bank comes in and forecloses against the property, if your lease was after the mortgage cuts you off. And so the bank can foreclose against the landowner and your lease is, you know, out the window. Bankruptcy is another, you know, they can cut off your leases. So you might think you have a valid lease, but there could be someone kind of back in the shadows ahead of you that has superior rights. And so, I was talking to great guys and saying, hey, if you're going to make this kind of investment, you know, maybe you actually want to invest in what we call a stub search, where a title company actually goes in and looks at the chain of title and the history and says, okay, hey, there's a mortgage against here. There's a lien against the landowner that, you know, because if someone has a lien against the land, they could foreclose against that. And again, cut off your rights. So if you're only leasing for a short period of time, and it's just, you know, crop ground, probably these things don't worry you too much. But if you start saying, hey, I'm going to invest in some tiling, I'm going to do a long-term lease, maybe I'm going to put a barn up on that piece of property because I have a 20-year lease, then these are things that you want to start thinking about because you could get cut off.
Where does oil and gas lease fall in that? And mineral rights?
So typically mineral rights, they give you, you know, they can come in, and so even though the mineral rights are below the ground, the company has the right to come in above the ground to access their mineral rights under the ground. That's how that works, right? And so those can be superior rights as well. And so.
And they're recorded, so you would be on notice of it.
Right.
There are a lot of streets of property that have two against the same property, oil and gas leases, which I didn't realize they could have two different companies.
Right.
Mm-hmm. Yeah.
And the problem with that is, so lots of times those oil and gas leases, they may be expired, but no one ever files, it seems like no one ever files a termination agreement. So, you think it's expired, but maybe it has, maybe it hasn't. Of course, you might think it expires, but the oil company might have a different perspective and say, well, New York passed this law, we can't drill, so the lease didn't really expire because it's what we call force majeure. And so, then you're fighting with the gas company, and it's like, hey, do they still have the right to lease the property, or did that expire?
And some of them are out of business, but I found a few that are still either they've been assigned to a company that's still in business, and you can go to the company and they're pretty friendly because mostly by the term of the lease, they do expire within 10 years. You can go to the company and they'll do a termination if it's expired 10 years ago. So, and they'll record it.
Life estate, which I didn't have, and Alex probably runs into this with appraisals. Life estate, so, mom has transferred, and Kelly actually had this applied in Pennsylvania doing the solar lease. Mom transferred the farm land to the son, but retained the life estate. So technically, mom is still the owner for the purposes of getting the benefit of the land. So the rent check should actually be going to the mother, not the son, because mom has life use or life estate. So if you're doing that, you actually want the mom to be the one signing the lease, not the son, because the mother is the one with the superior interest in the land. So mom could go out and, actually rent the land to somebody else, and you're renting it from the son. And I actually have this situation with a client going on right now. And it's a little bit of a mess.
I thought if the mom had left the property, the house, it was done.
Well, now it comes back to, is it life use or life estate? So a life estate is more a legal term that says as long as I'm alive, I have an interest in this property. And the only way to extinguish a life estate is to die or to, give it up. Life use, which is how we'll do it a lot of times, is as long as I'm using the property, I get the benefit from it. But if I give up my use of it, if I move away, then that extinguishes, my rights to it. So life use is more of like a Medicaid nursing home planning tool, where you might want mom to still have some benefits, but if she goes in a nursing home, you don't want the money to go to the nursing home. So you say, okay, mom has life use. She gave up her use because she had to go to the nursing home, and so now her rights are cut off. So you really got to look at the document. You got to look at the deed, really, and that's what we got into Pennsylvania. Mm-hmm. And Kelly, actually, 3 attorneys looked at it, and 3 attorneys had different opinions as far as what actually was going on in that situation.
2 out of the 3 agreed that it was a pure life estate. There was language in it that had reserved mom's use limited to just the house and the yard, and so the interpretation was that as long as the solar, in this particular case, we were dealing with a solar lease, as long as the solar panels were on the 75 acres that didn't have the house on it, we were okay with mom's use, although the deed had property defined in a weird way that it could be argued by Medicaid planning or us and the solar lease people to be that she technically is entitled to all of the land that was there. So we figured the safe bet is to leave mom on the lease and son on the lease, and however mom and son work through who gets the rental income is up to them, and just alerting everybody that rental income could really affect mom if it's interpreted the way that we were interpreting it. So.
And that was classic, the attorney who prepared the document knew what was intended. So he's saying one thing, and Kelly and the solar company are looking at it, not knowing the history and saying, well, property is capitalized. It's a capital P. That makes a defined term. What did you define property as? And you define property as everything. From a literal construction standpoint, we say, well, she's got a life use of everything. And he's saying, no, that's not what was intended. It was just a house. It's like, I don't know if you read it, was on the news, the $10 million case in Maine with a dairy trucking company, and the way the main statute was written, and they left the comma out, and so now this company has to pay $10 million in overtime, basically, because of the comma and the way it was interpreted.
Question on that, so
Oh, yeah.
if you're gonna go with solar leasing, should you parcel that off so that you don't get into some of the issues you're talking about right now?
Yeah, we were gonna talk a little bit about, you want to talk about solar leases in
I don't care if it's just solar, but I mean, anything along that line. Everybody, solar seems to be the popular buzzword at the moment, but should you, if we're gonna be dealing with 20 acres or 40 or 10 or whatever, should we be looking at parceling that off so that it doesn't interfere with all the other ownership of the property?
It's an option if you can subdivide the property, if it's large enough to subdivide and not cause problems as far as that goes with the town and subdivision rules. It's certainly an option, and possibly forming an LLC to have all the rental income going into to the LLC and keeping it away from other business ventures that are going on with the farm or whatever else you're doing with the property. That certainly could be an option if you want to keep it separate, purely separate from an agricultural business or estate planning purposes.
I think neither Kelly nor I are really big fans of the solar leases. I mean, we've each looked at a lot of them, Kelly more than I, but I think there's a lot of potential issues there, and I think the ag assessment is one of the biggest ones. And that's, that right there is probably a reason alone to try to put it on a separate tax parcel. So that way you're only losing the ag assessment on that parcel. Otherwise, if they come in and they put a solar farm on 40 acres and it's a 200-acre tax parcel, does your town say you're losing the ag assessment on all 200 acres? Because when you put on a solar farm, you're no longer ag anymore. And so there's a legitimate argument that says you lose the ag assessment on all 200 acres. And then if you lose that, as you guys know, there's a lot of penalties when you take something out of, an ag district or getting ag assessment, you have to pay it back. Who's going to pay that back? Is that the landowner that's going to pay that back, or is that the solar company that's going to pay that back? So I try to discourage clients from doing these solar leases. And that's just one reason. I like the wind leases a lot more. Kelly doesn't like wind leases.
I don't like
either,
any of those type of leases.
but I'm okay with the wind leases.
What about like self-governing?
Those don't bother me too much, and I think you're pretty comfortable with those.
Yeah, those ones are usually pretty tight, the ones that I've reviewed. They're only affecting a small area and very limited access. There's usually just one way in and one way out to cell towers. So those are pretty, overall, I think I find those more reasonable than the solar and wind. But I feel with the solar and wind, there's a lot of moving parts that we have to pay attention to, especially with agricultural clients that we have. How they're accessing the panels or the turbine has a lot to do with how you as a property owner are using the property. So I have to get into a lot of how the property is currently being used before it's a good idea to consider for someone to get that income for that purpose.
And that's always, especially with wind turbines, you can never get them to commit to the exact location of where those turbines are going to be until they go in and do all their studies. And of course, they don't want to do all their studies until you have signed the lease. And that's my biggest concern with clients. I always say, you don't know for sure where they're going. And they're like, well, we've got maps, and I said, yeah, but you sign this lease and they can put it wherever they want after you sign the lease. So we just had a couple of clients sign them, and they're kind of taking a leap of faith that they feel they've got it hammered out close enough that they can live with the location of the turbine and the access road. But
You have to finesse those agreements. I think it's hard. We find that these companies are so aggressive with our clients that it's a good thing that they call us, because once you start talking, most of the companies have an attorney that we can talk to. Attorney can talk to one another about the particular proposal that's in front of the client and say, there are certain provisions that are just not gonna work, and we all really need to finesse this agreement and add some more provisions and build in certain protection for a property owner, that once you really get in and have a conversation and move away from the salesperson, you can make an arrangement that works, and so that it's more like a partnership rather than the sales guy just saying, this is a great deal, you can't pass it up and forcing you to sign it without having a lawyer look at it. It's really, really ill-advised because they can be negotiated and finessed in most cases.
Jerry's idea of subdivision sounds like something very simple, very easy, but when you get into your town, and unless you've sat through 3 or 4 town planning board meetings and seen it up and down, you don't know how they interpret things, and it can be a really big deal and very costly.
Yeah, some towns are very easy to subdivide. It's no big deal. Now, town of Marcellus, you think, it's an ag community. It should be pretty easy. It's not very easy, is it, Keith?
Preach that.
Mm-hmm.
So it really does depend on the town. And those field people that show up for the solar company or the wind company, they're not working for you. They don't care about you. They don't have your best interests. They get a paycheck from a company, and they tell you, oh, these leases have been looked at. It's a fair lease. It is not a fair lease. Those leases are really one-sided, and they're one-sided in favor of the solar company and the wind company. So don't ever feel pressure to sign something right away, because you'll probably regret it. Let's see. So tax considerations, they may drive the way a lease is structured. So there's a manufacturing tax credit. A lot of people aren't even aware of this, but dairy farms qualify as manufacturing units. And actually agriculture in general, I don't know all the specifics. I always leave it to the tax people. I don't know if Alex, you run into it all, and you just know they talk about it in the office, right? That's kind of like the same thing. We talk about it, but the tax people get into it. But basically, the tenant can claim a 20% manufacturing tax credit on property taxes. There's certain requirements that have to be met. So again, the tenant doesn't have to be the landowner. Keith can own the land. I'm the farmer. If I pay the taxes directly to the taxing authority and I have a written lease with Keith, I can claim a 20% credit against those taxes. Now, normally it's just the county taxes, because if you're a farmer and you're getting the farmer school tax, you're not allowed to double dip. So you can't get the farmer school tax credit and the manufacturing tax credit. But in Keith's case, where he's not going to qualify as a farmer, then chances are I can probably take the 20% on all the taxes I'm paying, not just the county taxes. So again, that may drive the rent, because the tenant may say, hey, I can pay you more rent if we set up this agreement, because I'm going to get the taxes back that I pay. So it's just something to keep in mind. Farmer school tax, again, oops, go ahead.
Based on what you just said, are you recommending in that case that the tenant actually pays the taxes?
It can be a reason for the tenant to actually pay the taxes, yes.
My position has always been whoever's responsible for the taxes should be paying.
Right.
And if it's the landlord that's responsible, then I've encouraged the tenants or the landlord to collect enough rent so that they could pay the taxes and no chance of default on behalf of somebody else.
Right, and so those become the considerations. Now if you're the landowner and you're depending on the tenant to pay your taxes, what happens if your tenant doesn't pay the taxes? That creates problems for you as the landowner. But that can be addressed in the lease, and maybe have the requirement that the tax money has to be paid in advance or an escrow or things like that, so you can work around it. It's really more a tenant-driven thing, so the tenant needs to sit down with their tax person and say, hey, I'm renting 500 acres from Keith. If I pay the taxes and I have the right kind of document, can I actually claim this as a tax credit when I file my taxes? And if the answer is yes, then you probably go back to the landlord and say, hey, look, I'm going to get this money back from New York State. Let's structure this in a way that's a win-win for both of us. like you said, ag assessments, again, making sure that you're qualifying for ag assessments, making sure the lease is 5 years to do that. Sometimes, typically rental income, if you're the landlord, the good thing about rental income is it's not subject to self-employment tax. So that saves you some money. But sometimes maybe you want it to be subject to self-employment tax. So maybe you want to do some kind of crop sharing arrangement. My only comment there is crop sharing, in order to qualify, there has to be material participation. So there's just certain rules that you have to fall under. So again, I don't want to get into a whole lot of tax details. I just kind of throwing something out there. But I think that manufacturing tax credit, if you're a tenant, renting a lot of land from a landowner, that's really something to talk to your tax, who's ever doing your taxes and have that conversation. Insurance, everything's great until there's a problem, and then, whose insurance covers it. So again, if you're a landlord, you probably want to make sure that the tenant has insurance. So if someone gets hurt, when the tenant comes on the farm and is farming and the tractor runs into the ditch and someone gets killed, you're going to get sued as a landlord because you're the landowner, and they're going to always want to sue the landowner. So hey, did the tenant have insurance? Is there a certificate? If you're the landowner, you probably want to be listed on that insurance policy because you want the tenant's insurance company to be paying your legal fees. And so in order for that to work, you have to be listed on the policy as an additional insured. They should give you a certificate of insurance every year so that you know that you actually are listed on the policy. And these are all things that, the insurance agents are used to dealing with. So if you call them up and say, hey, I need to add so-and-so to my policy, or I need a certificate of insurance, it shouldn't be a big problem.
Or that you're immediately notified if they cancel the insurance.
Right.
So sometimes a year may be too late because the tenant may have canceled their insurance throughout the year. So you want to make sure that if you're added as an additional insured, that there's a notification provision in the lease and on the insurance policy that you're notified of the cancellation.
Right. I was at a meeting the other day with a client. They're leasing all their land's in the trust now. And they said, geez, we got a letter a couple months ago from an insurance company to say you didn't pay your premium. And they're like, we don't even have this insurance company. We don't know where this letter came from. Well, it was the tenant hadn't paid the premium for the land that they were leasing, and so the landowner was getting notification that the tenant hadn't paid the premium. So, but like Kelly said, if you don't get that notification, you think there's insurance, and then it lapses, and then there's an accident, and guess what? There's no insurance. And the benefit, one of the biggest benefits of the insurance is not only, someone gets hurt and they're going to pay out, is paying your legal expenses to get to that point. I mean, that's where if you're covered under the insurance policy, the insurance company hires the attorney to defend you in the lawsuit and pays those legal expenses while they're, defending you. Default, and I only like to put this slide in, but Kelly always makes me put it in, so I'm going to make her talk about it.
Well, it goes hand in hand with insurance. It's something that nobody thinks about until there's a problem. That's why we were encouraging that there should be written leases. They should be really detailed, because when there is a default, you will fall back to the lease to be able to enforce it, to protect. With you guys all being landowners, you want to be protected when the tenant isn't paying you rent or hasn't abided by other provisions in the lease agreement that you're seeking to have enforced. And then the other interesting part about making sure you have default covered would be in the sense of, oh gosh, I just remembered.
But yeah, I mean, default tends to protect the landlord more than the tenant, because usually it's the tenant that is the one that's going to.
Well, then I was thinking about crops. So if you're the tenant and you planted the crops, and the landlord is defaulting, and the tenant wants to go in and take out the crops that they planted, then it becomes who owns the crops? Is it the landowner or the tenant? And if you don't have a written agreement, you're gonna end up in a justice court in a township somewhere arguing over who owns the crops.
And that's a big thing, you know, if something happens, you have the right to come in and harvest that crop after the fact. And you don't, you know, if you've invested all that money to grow your corn crop, you probably want to make sure that you've got the right to come back in and chop it or combine it in the fall. So this comes up a lot. You know, what happens to that lease if the property gets sold? So leases run with the property. And so typically, if the lease doesn't say otherwise, that lease is an encumbrance against the property, and which means that if you sell the property, you're buying it subject to the lease. So again, I'm leasing Keith's farm. Keith sells the farm to Kelly. Kelly wants to farm it. Kelly can't farm it until my lease is up, because I have a lease with Keith, and even though he sold it, she bought it subject to my lease.
But that is different when you talk about superior rights. Because if the bank takes it over from him, they still can kick you off. Is that what I heard you say?
Yes. Now, yes, the bank is always superior, and the bank is always first. And usually what happens, what you should do is, if you have a long-term lease, you should record what we call a memorandum of lease. And that just gets recorded in the county clerk's office and puts the world on notice that you have this lease. Now, if you do one of those, and let's say Keith and I enter into a lease 5 years ago, we record one of those, and now Keith goes out and he wants to mortgage the property. Okay, now I'm actually in front of the bank, because my lease got recorded before the bank's mortgage came along. Guess what? The bank is not going to loan Keith money with me having a superior right, because every lender always wants to be first. So what the bank is going to do is they're going to go to Keith and say, you got to get Steve to subordinate to our mortgage, which means I'm going to have to sign a document that gets recorded that says, even though my lease was before the bank, I'm agreeing to give the bank superior rights. Because the bank, when they foreclose, they want to cut everyone off. That's why they make life estate holders sign a mortgage, because they want to cut everyone off, because, you know, they don't want any problems. They want the property back. They want everyone gone.
They want to be paid first.
They want to be paid.
Could you explain a little bit more detail about how you go about registering it in the county courthouse?
Yep.
Because we've had some of those circumstances here, and the words just kind of bubble out and go all over, but I'm not sure anybody other than the person who's involved understood what they did and how it protected them.
Tackle that first.
So I think with leases, you don't want to record the entire lease, kind of like a trust document or something that's private, because between you and the tenant, you don't want to have the whole world knowing in Cayuga County how much rent you're receiving, how much property you're leasing. So you don't normally want to record the entire document. So with the memorandum of lease that Steve's talking about, it's an abbreviated document. It's usually 1 or 2 pages and just spells out the parties and the tax maps that are involved. And a lot of times, if there's an option to purchase that particular tax map, that will be noted in there, so everybody's on notice that if we're going to buy this property, that we've got to talk to this tenant first and make sure that they have exercised their option, and then we can buy it.
I was at client the other day, and they said, gee, the neighbor approached us about buying a farm. We want to buy it because it's farm next door, but they said, oh, their tenant has a purchase option. What should we do? And I'm like, nothing until the tenant signs off on their purchase option. I said, was it recorded? They're like, yep, there's a memorandum. I said, don't touch this. I said, you've got to wait. And the landlord's like, oh, it's no big deal. Don't worry about it. I want to sell it to you, and I want to sell it to the tenant. And I'm telling my client, no, you can't touch this property until the tenant waives their right. They need to sign something that says, I'm waiving my purchase option, and you can go ahead and purchase it. And if it's recorded, that's where everyone gets protected, because it's part of the public record. So, you know, my client can Kelly and said, all right, can I have a right to buy this? Kelly would have found it, because when she did the title search, it would be in there, and she'd be like, oh, there's a memorandum of lease. Oh, and it has the right to purchase. Tenant waive it. Oh, well, then we can't close on it.
The tenant still has the right to finish up the lease.
Tenant still has the right to finish up the lease, so even if they buy it, they're buying it subject to the lease, unless the tenant agrees to give it up. And because there's that purchase option, the tenant has the first shot at it. So, you know, again, whoops.
Does the tenant that has the first shot because of that, does he have to match the other guy's price in it to get it, or is it because of money talk?
And give me a couple slides here at the end, and we'll talk about different ways and how that can play out, because the answer is it depends. So like I said, termination on sale, the general rule is when you sell the farm, the tenant's lease continues. Now again, if you're the tenant and that lease is recorded, you've done a much better job of protecting your interest, because now you've told everyone in the world that I have this lease. Otherwise, you know, someone buys it, they don't know about your lease, and they do something else, and you get messy. So again, it's another reason why you want to put things on the public record. If the lease does terminate, what about harvesting your crop? So we might have a document that says, okay, if you sell the property, landlord, the lease terminates. I get it. But if you sell it in June, those are my crops, and I have the right to come on until November, December, whatever, and harvest my crop. So that can be spelled out. Common law, so you go back to the days of the king and the knights and all that, which is what common law is. And basically says if it's an annual crop, corn and beans, by default, you should have the right to come back in and harvest that. If it's alfalfa, perennial crop, no. When the land gets sold, the perennial crop gets sold with it, or something Latin name, I forget how to say it now, so I won't even try. So again, it can all be spelled out in the lease one way or the other, but this can be a really big deal.
But then it goes to default too with an annual crop. And the tenant hasn't paid rent. Can you, when they harvest the crop, the landowner should have something in the lease that says if you've defaulted, I get the crop proceeds or a portion thereof the crop proceeds because you're defaulting under the lease and haven't paid rent for 3 months.
And that's where if I'm a tenant, it's like, I don't want that provision in there. So this again depends on what side of the equation you're on. Termination on death. So someone dies, does the lease automatically terminate? And this could work both ways. I mean, from a landlord's perspective, they say, you know, he says, well, I'm really renting it from Steve. And I know Steve, and he's got to do a good job, and he's farmed this for years, and he always takes good care of the land. And so as long as Steve's alive, I'm okay leasing it to him. But if Steve dies, and I don't know who's going to take over his farm, and I don't know what kind of job they're going to do, you know, Keith may say, hey, I want the lease to terminate upon my tenant's death, because I don't know who's going to take it over. And conversely, the landlord may say, hey, you know, I don't ever want to sell this land. I'm fine you renting it for years. You know what? If I die, my kids are going to want to sell this farm, and I don't want to be tied up with your lease. So, you know, if I die, we need a provision that it says that this lease terminates upon my death, so that my kids can then sell the land and not have to worry about your lease.
That's the most prevalent question that we get. So either don't have kids or don't die.
Yeah.
Sure, I don't see a divorce section.
What's that?
If
the landlord got went through a divorce, how complicated that get?
It shouldn't get too complicated for the leasee, other than the landlords, you know, the husband and wife have to split it up. And so again, the lease should be, the property should be split subject to your lease, so you should still be protected. But again, what happens if it's got to get sold in order to pay the spouse out or mortgage? So divorces can mess everything up as well. I mean, that's another complicates thing. That's the other benefit of having leases and having having a memorandum recorded, because if you're the tenant, it's going to help protect your rights from someone coming in and trying to undercut your lease. You know, if you're just leasing cropland, it can be relatively easy. But now if you start leasing buildings, you got a machine shed you're leasing out, you got a freestall barn, whatever, you know, who's going to maintain it? Who's going to repair it? Tiling, you know, like I said, who's going to pay for the tiling? Is the tenant paying 100% of the cost? Are you going to do some kind of cost share with the landlord? A lot of that probably depends on how much tiling you're going to do and how long the lease is going to take. And probably the longer you're willing, if you're a landlord, the longer you're willing to make the lease, probably the more willing your tenant's going to be to pick up the cost of the tiling. You know, farm roads and ditches and hedgerows, you know, who's going to maintain them? Farm road gets all rutted up in the fall, harvesting crops. I mean, who's supposed to come back in and fix that road up? Particularly if it's some kind of shared road. And then, you know, how does the land get left at lease termination? So my dad, like I said, he's leasing the land out. There's a provision in the lease that says, prior to termination, tenant, you have to seed everything back down to grass. My dad's going to pay for the grass seed, but that's the deal. He didn't want things left in stubble. It's got to get seeded back down. So again, those are all things that can be addressed in the lease, should be addressed in the lease, and then again, who pays for it? Because some of these things, as you know, are relatively expensive. Assignability kind of goes back to that thing that I was talking about with Keith, where, you know, if I'm the tenant and I die, you know, he wants to only work with me. Well, can this lease be assigned? Can I take my lease? I have a lease with Keith, and I'm leasing his farm, and I say, oh, gee, I don't need this land anymore. I'm going to lease it to Kelly. I'm going to sublease it to Kelly. Well, Keith may not be okay with that because he knows that Kelly doesn't do a good job of farming. You know, she spreads manure all over the place, causes all kinds of problems, and he's like, I don't want Kelly getting my right to step into your shoes. So again, that can all be spelled out. Can you assign your lease to somebody else without consent? Or do I need to go to Keith and say, hey, Keith, I really don't want to lease this land this year, but, you know, Kelly just does a really good job, and, you know, I want her to be able to do it. And Keith was like, yeah, I'm fine with that. I'll let Kelly do it. No, I don't want her to do it. If you're the tenant, you know, what happens if you form a new business entity and you want to say, hey, I want to assign it to my new business? It's really the same. You might want just the unilateral right to do that. You don't want to go back to Keith and say, well, Keith, I formed a new entity. I brought my son or daughter in. You know, I want them, you know, to be operating it. Keith might say, oh, gee, I don't know if I want that. I don't think you're paying me enough rent. You know, we ought to be able to terminate this lease now. So if you're the tenant, you might be like, hey, if it's to another family member or to a related business, I should be able to assign it without having to get his permission. So every time if you're the tenant, every time you got to go back to the landlord to do something, they got a little leverage over you. So it's like, oh, gee, well, yeah, I'll agree, but I need more rent. Or, you know, so you got to be careful there. Dispute resolution. Of course, I tell you, there's never any fights, right? But you know, how are you going to resolve a disagreement? Is it going to, do you go to court? Is there mandatory arbitration or mediation? You know, arbitration mediation is a lot cheaper than court. Who's going to pay for that? You know, choice of law provisions. So, you know, what state law controls? So everything we're talking about today is, you know, New York law, because obviously we're licensed in New York and we understand New York law. I don't know anything about Wisconsin law. So what if my land is in New York, but, you know, Keith now, he's a landowner in New York, but he lives in Wisconsin. So we're signing leases back and forth through the mail. What law controls? Is it New York law or is it Wisconsin law? Because Keith signed the lease in Wisconsin. So is he thinking Wisconsin law applies to all this? And I'm thinking New York law applies to all this. So again, you can have a provision that says this lease will be interpreted under New York law. And it doesn't matter where Keith signs it. We've all agreed the land's in New York. We're going to use New York law. So again, it can be critical if you're dealing with out-of-state landlords, knowing, you know, what potential might be out there. Okay, memorandum of lease, we pretty much talked about this. The big thing is that TP 584. I know you can explain that better than I can, but
It's a document, like a deed. There's two documents that get recorded with a deed with the memorandum of lease, the TP 584. Depending on the term of the lease, if it's 42 years or more, there's consideration to be considered on the TP 584. But if it's a short-term lease and you're recording a memorandum, it's just the vehicle to get the document on record. The landlord and the tenant both sign it, and you identify the property, social security numbers, and that allows the memorandum to be recorded in the county clerk that you have the property in.
so that comes up a lot. People will be, the tenant will be like, hey, I want to record this lease, or I want to record this memorandum. But you can't do it without the landlord's consent because they need to sign that TP 584.
And it won't be recorded without the TP 584. So someone can't unilaterally go do that unless both parties have signed it.
And again, those memorandums, they have to be notarized, has to be an original document, just like a deed. You can't record a photocopy of a deed. Anything that gets recorded in the public record has to meet certain requirements. So be conscious of that. Let's see. And we'll talk about this, from a purchase option. Again, if there's something in there, that can create problems for the landlord, because as you've already seen, the landlord, my early example, the landlord wanted to sell the farm to the neighbor, but the tenant had that purchase option. So again, the tenant was protected because they had the purchase option, but this was going to create a title issue for the landlord, because if Kelly's representing potential buyer, Kelly is going to say, you can't close on this until we get this issue cleared up, until that tenant signs off on their rights. Otherwise, they can come back and sue you. They might not even sue the landlord. They may just come back and sue you as new property owner. Now you bought the farm and you bought a lawsuit. Okay, so options to purchase. So these tend to be very tenant-friendly type provisions. So if I'm representing a tenant, I push really hard to get these in here. They don't have to be bad for the landlord. They can be neutral. But there's a couple differences to think about. And terms get used a lot, and they have different meanings, at least from a legal perspective. So, people say, well, I have a right of first refusal, I have a right of first offer, I have a purchase option, they're all the same thing, right? Well, not really. You got to kind of look at, and some people call it a right of first refusal, and it actually isn't a right of first refusal. It's actually more of a purchase option. And so again, people use that right of first refusal. That's the most common term I think we probably run across, but it may not actually be a right of first refusal. So what is a right of first refusal? So Keith's example, so he wants to sell. And so he goes to Alex, and I have a right of first refusal on it. So Keith goes out, says, I want to sell it, go to Alex, and I get a purchase contract signed with Alex, and Alex is going to pay me $2 million for my farm, and we're going to close within 60 days and blah, blah, blah. I have a right of first refusal. That means that Keith has to take that contract that he just signed with Alex, give it to me, and I have the right to match that offer because I have the right of first refusal. So that's, I basically would step into Alex's shoes. I have to take the same contract that he offered. So I have to, it's $2 million cash, whatever it is, I have to match those terms. And then I take over Alex's contract. So it's relatively simple to implement because, and Keith's really not out anything because he went out and he negotiated with whoever he wanted. But the deal was I had the right of first refusal, so you got to bring it back to me to sign off on. So like I said, landlord's perspective, it's really not all that bad because they can offer the farm, Keith can market this farm to anyone he wants. All I know is that at the end of the day, before it gets sold, I'm going to have a shot at it. And he can negotiate any kind of price that he can get. And he knows that if I want it, I have to match that price. So the only downside from Keith's perspective is it probably is going to delay the contract a little bit, because if usually in there, you know, it says like the right of first refusal, I might have 10 days. So he's got to go to Alex. Alex signs the contract, brings it back, and now it's going to sit for 10 days while I have the chance to consider whether I want to match it. It may limit Keith's marketability too, because Alex may be looking at that and saying, you know, I'm going to have to negotiate this. I'm going to have to get an attorney. I'm going to have to, you know, spend $500-600 in fees and time and effort. And then I'm going to lose it anyway, because I know Steve's going to buy it. So, you know, do I want to go through all this hassle of potentially negotiating the contract that I know I'm never going to get to, you know, close on? So again, it might limit who Keith can actually market property to, because they know, hey, Steve's waiting in the background. He's just going to jump in and steal it from him. Anything to add on that? No. So from the tenant perspective, hey, you're the tenant, at least you're getting the opportunity to buy the property. Okay, before it gets sold, they're going to come back to you and you're going to get shot at. So it's better than nothing. The downside of this is, you know, Alex has got a big farm. He's great equity position. He can afford to overpay. And I know he's going to overpay because he can, and he really wants this land. So he's going to give Keith a highball offer, overpaying, hoping that he can drive up the price that I can't match because I'm highly leveraged and I just bought the farm down the road. And there's no way that anyone is going to loan me any more money to take on another farm. And so Alex is like, hey, I'm going to highball it and I'm going to get the farm. I also might, 10 days. If you go to your banker in 10 days and say, I need to borrow $2 million, probably a banker is going to take longer than 10 days to get you an answer on that. So that may limit your ability to even exercise your rights. Could you negotiate longer? Yeah, but Keith doesn't want to tie up the property for more than 10 days. He wants to be able to sell it. I'm in a very defensive position. I have to react. Keith is really driving the bus, and I'm reacting to what's going on, and I don't have a lot of time to do it. So it's better than nothing, but it's not all that great. So then we have what's really a right of first offer or a purchase option. Right of first offer is, if I have a right of first offer, he has to come to me first. Okay, it's not a right of first refusal, it's right of first offer. So he has to come to me first, and he's got to say, Steve, I want to sell the farm. Do you want it? That's a very different situation than a right of first refusal where I have the right to refuse it. So then Keith and I have to kind of negotiate the terms, what's the price going to be, all that. You can see this is a lot more complex because, what's the price going to be, what are the terms going to be. Keith and I have to be able to reach some kind of agreement. What happens if we can't reach an agreement? What if Keith is being totally unreasonable and, he wants more than the property is worth because he just wants to get out from this deal. So he's like, Steve, I know I gave you the right of first offer, but, I want $3 million for it. And we both know the farm's only worth $2 million. But he refuses to budge. Well, I have this right, but how much good did it do me because I'm not going to pay $3 million for it. So, how do we determine that purchase price? Because that's usually the biggest sticking point. So is it predetermined? And it can be. You can build into the document that the price is going to be $2 million if it's within the next 5 years. If it's in years 5 to 10, it's going to be, $2.25 million. It's going to be indexed for inflation. Or this is where Alex comes in. We're just going to agree that at the time that we're ready to sell it, we're going to call up Alex. He's going to come out. He's going to do an appraisal. He's going to tell us what the market value is, and that's what the price is. When is it exercisable? Is Keith in control? Does he get to determine when he wants to sell it? Or do I have the right to go to him, which this is more a purchase option? Do I have the right to go to him at any point during that lease term and say, Keith, I'm ready to buy the farm now. So you sell it. We got to reach a deal because I'm exercising my purchase option. So from a landlord's perspective, is there any benefit? Probably not, other than you know, this comes up a lot. If you're the senior generation and you have leased the land to a long-term farmer for the last 15 or 20 years, and you want to make sure that farmer has the right to buy it, and you're worried that your kids are going to come in and just try to get the most money possible, then this might be a good way to kind of protect the farm from your greedy heirs. You know, your kids are going to get paid, but they may not get paid top dollar because you're going to limit how much you want them, how much they get. But you're more worried about, as a landowner, kind of taking care of that long-term tenant who's done a really good job taking care of your farm all these years. Landlord cons, you know, they're probably not able to negotiate the highest price, just because, again, it's either predetermined or it's by appraisal. It does reduce the marketability because the tenant has the first bite at the apple, it's the first shot to buy it. It may never hit the market because Keith has to come to me first and we negotiate the deal and get it done. And then, you know, if there's a purchase option, Keith may actually have to sell it before he wants to sell it because he gave me his purchase option to exercise. So from a tenant's perspective, you know, this is as good as it gets because you have the first shot to purchase it. You're protected from a bidding war because I'm not bidding with Alex over what the price is. I'm not depending, you know, it's either going to be by appraisal or we've already pre-negotiated the price. I'm, as a tenant, in a much more offensive position. I'm kind of in control of the situation. I'm really driving it more. I probably have time to line up financing, call my banker, work things out. And so from my perspective, is there any downside to it? No. That's why if I'm representing a tenant, I want to do some kind of purchase option, right at first offer. So, and then one thing, we actually just got a lease in the mail, or that came to us over the weekend, very similar to this, and Kelly and I had a conversation the other day, what's the best way to approach it? So in there, the landlord had provision, what was it? It was the
landlord was determining the price point. So it was a right of first refusal, but the landlord had the price point. And so we had discussed trying to phrase it more of an option because we represent the tenant.
Right. So that was a, you know, same deal. I didn't want our client kind of being in the defense of, again, you know, there's no price, there's no method for appraisal, there's nothing like that. It was basically like, hey, landlord's going to go out and market this property and we're going to have to match a price. And so we're going to have a conversation with our client, the same thing. Hey, maybe rather than this, you know, can we try to have it at least be determined by appraisal? Okay, landlord, you want to sell, come to us first and let's go get it appraised, and that becomes a purchase price.
And we didn't even have the option of a bona fide offer.
Right.
So it was truly driven by the landlord. So even if he got an offer, the way the lease was structured, it didn't necessarily mean that the landlord was going to accept that one and present it to the tenant. It just meant that the landlord could say, I want $5 million.
Right. And that's what we're going to tell the client. Okay, if the landlord won't agree to doing what we kind of want with appraisal, the way it was set up is basically Keith comes to us and says, yep, Steve, I'm ready to sell $3 million. It's not worth $3 million. So, okay, we're not going to exercise our right because the bank's not going to loan us $3 million for a farm that's worth $2 million. So maybe we can get that landlord to agree to say, okay, Keith, come to us first. Tell us what you want to sell it for. If we think you're being ridiculous, fine, go ahead and market it to whoever you want to market it to. But then you have to come back to us with a bona fide offer and say, okay, if Alex is only willing to pay $2 million because Alex knows that's what farms really worth, then give us the right to buy it at $2 million. Because it wasn't fair to offer it to us at $3 million and then you sell it later on for $2 million. So we're going to have that conversation and try to get that negotiated. So
There's a lot of fine talking points. If this is the first time you've heard these two terms discussed, at least hear it a second time from somebody, because there's a lot of fine points in there. And I would challenge almost anybody, one shot out of the listening curve, whether you got it right or whether you got it wrong. It's just too big a gamble to make a mistake based on what you thought you got right.
And this is the area where it makes a huge difference whether you're a tenant or you're the landowner. Because if you're the landowner, you're going to approach it very differently than if you're the tenant. And Keith's right, there's so much, because we hear all the time, oh, I have a right of first refusal. Okay, what, is there a right of first refusal? Is there a right of first offer? They're used interchangeably, but they're really not.
A lot of coffee shop talk.